Hi, I'm Lian Wan. I'm the Justice Reporter of Rappler. And for this episode of Rappler Recap, we are going to recap what happened in the just concluded first day of the oral arguments on the anti-terror law of the Supreme Court. It started 2:30 p.m. earlier and it finished 5:30 p.m. So mga 3 oras silang nag-deliberate, nag-argue, and it's kind of a bit of a departure from the Supreme Court practice where kapag ginanahan yung mga justices, they can continue well into the evening. Sometimes we finish 7 p.m. or 8 p.m. But earlier we saw that when the clock hit 5:30, tinapos na ni Justice Marvic Leonen at itutuloy nila ang session 2, a second session on February 9, which will begin on 2 p.m. So what happened kanina was that of the 7 oralists who were handpicked by the 37 petitioners got to deliver their opening statement. The 7 oralists were attorneys Jose Anselmo Cadiz, Chel Jokno, John Molo, Evelyn Ursua, Representative Edsel Lagman, Attorney Nery Colmenares, and Attorney Alga Marlatif. Solicitor General Jose Calida was there earlier, but he didn't get to deliver his opening statement yet, at hindi pa rin siya in-interpolate ng mga justices. So it was only the petitioner's turn for today. So what were the highlights of the oral arguments kanina? Attorney Chel Jokno of the Free Legal Assistance Group raised that there's no other law that punishes the state of mind of one person. That was his point. Sinabi niya na because the definition of terror defines terror as an act that intends to cause serious death or serious harm. Yung intent, yung pinapunish o pinaparusahan ng batas. Kaya sabi niya na parang ang state of mind yung paparusahan ng batas and there's no other law that does that. This issue was threshed out during the interpellation of Senior Associate Justice Estela Perlas Bernabe. She asked Attorney Jokno kung yung bang definition of terror under Section 4 was a novel creation of the Philippine Congress or was it based on any international statutes. At sinabi naman ni Attorney Jokno that according to the Office of the Solicitor General, binase nila ang definition na ito sa Comprehensive Convention on International Terrorism that was proposed by India. Pero sabi ni Attorney Jokno, merong significant difference. The Comprehensive Convention on International Terrorism has crimes and it doesn't only punish intent. As opposed to our anti-terror law, which punishes intent. But Justice Bernabe said, kapag tinignan mo yung convention, meron din namang mga salita doon that says intends to cause serious harm or death. But Attorney Jokno made the point that as in the old Human Security Act, meron kasing tinatawag na predicate crimes. So what are predicate crimes? Predicate crimes are common crimes such as murder, rebellion, or piracy that need to be proven first. And then after ma-prove na merong predicate crime, then that's where you assess if there was an intent to cause serious harm or to cause death. Whereas in the Philippine anti-terror law, parang yung intent daw yung agad na ina-assess. That's why he said no other law punishes our state of mind. So after the interpellation of Justice Bernabe of Attorney Jokno, nag-interpellate si Justice Marvic Leonen. He called to the rostrum his former student, UP Constitutional and Political Law Professor John Molo. This was a very interesting exchange between a former professor and his former student. Now, Justice Leonen was hammering on the point of the ripeness of the case. He said that shouldn't we wait for an actual case to happen? Shouldn't we wait for an injury to happen? He was making the example of maybe the case of the Aitas who were charged under the anti-terror law. Maybe that should have been the actual case and not this. But the 37 petitioners have all alleged that this case is valid or viable to a facial challenge. Facial challenge means you don't have to prove that you suffered direct injury for you to be able to challenge the law. But Justice Leonen said that while he understands the fear, the theoretical fear, he also says that as a justice of the court, they should not substitute with the wisdom of those who crafted the law and those who advised the president. And sinabi ni Justice Leonen that maybe we should wait for the executive department to to implement the law first and see how they react. And that's where Attorney Molo said, I think, what is the most quotable quote of the entire oral arguments, wherein he said that deference or judicial restraint ends when the Bill of Rights begins. But not satisfied with that, Justice Leonen said that shouldn't we wait for the government to actually violate the Bill of Rights? And Attorney Molo said that the actual passage of the law is in itself a threat to the Bill of Rights, and therefore, up until the very end, he was firm in his belief that a facial challenge was valid. Justice Leonen was, I think he was eager to continue more in this line of questioning, but he was cut by Chief Justice Justado Peralta because it was already 5:30, and so they had to finish at 5:30, and they're gonna continue next Tuesday beginning 2 p.m. And so if you're following this case, tune in again to Rappler. We have a live updates page. We're tweeting and we're uploading stories. So if you want to know more, we have a microsite on Rappler. Go there and see you on Tuesday. See you next Tuesday. Thanks again. This is Lian Wan, Justice Reporter of Rappler.